We're going to invite Jeff Murtaugh and Mark Shin up here to answer questions. And just so everyone knows who's viewing this, we've invited some agents. Thank you for coming today to ask some of your specific questions, because there's a lot here. And we want to thank our company attorneys, Eric Tomei, for putting this presentation. He spent a lot of time and effort. And there's probably some additional color that he'll add to it regarding his conversation with the Arizona Association of Realtors attorney, Scott Drucker, and what he has talked about regarding lawsuits that are currently being launched here in the state of Arizona that affects all real estate agents, not just realtors, but agents too. Jeff and Mark, questions.
I want to be clear, everybody, that if a TCPA lawsuit comes in, it is not an Arizona Missions issue, because both our contract and our policy and procedures require agents to follow TCPA. We will look to you for any penalties that you potentially may have if you get sued by breaking the law.
I'm not sure if there's any questions that we.
I have a question. Would it be possible at that point to have maybe an insurance policy for any of those kind of areas that you could possibly make?
That would be up to the individual agent to find that policy. I doubt that there is one that you can get a policy that can cover breaking federal law. But sure, you can certainly try. I don't believe you'll find that available to you.
The premiums are probably going to be pretty hefty too.
Yeah, it's certainly not covered with errors and emissions. Basically, errors and emissions. You can't get errors and emissions for breaking a law.
Sure.
You made a mistake,
Yeah, it's not that we're going to be breaking the law, but you got to be protected. And
correct. So that's why we put this out to really. This is more of an education piece for all of our agents to watch and understand how we have to follow these laws that have been in the books for a long time. And now that we're seeing lots of lawsuits coming to our city, we thought it was really important to do that education.
Like with so many things, when in doubt, call first. It's always easier to prevent the mess than to clean one up. So it's always easy to make a phone call if you have any questions before doing something, because afterwards it's, trying to close the barn door for the horses going. It's not always able to fix something after it's occurred.
So we're doing online ads, and that person that has put their information into our ad, and given us their number, we reach out to them. If they turn out to be on the do not call list, is that still a violation?
Well, you should check the do not call list first.
But what if they give us their number?
You should still check the do not call list first and understand that, and then call us and ask us. If you want to see what it is they give them the number, remember, if it's on the do not call list, you got to get it in writing.
Can I put a consent on the ad?
Eric's got it.
Yeah, let me add to that. I think you absolutely can. If you put right where they're typing in their phone number, where they're giving you the phone number, if you put that information that they are, that you comply with the do not call list, if they're on the do not call list by putting their phone number in, they've given you express written consent to do so. Now, what's important about that is if you call me up 6 months later and somebody has said you violated, do we have access to that information? Have you retained that information? So not just getting it in the first place and putting that information out there, but making sure that you have that information available to anybody that's representing you when you get accused. Just because somebody signs that on the day they fill it out, doesn't mean they remember it 6 months later when they decide they want to file a lawsuit.
In that situation, with that authorization, what, 6 months or 18 months?
Right now, I'm hearing 18 months. And again, that's a good question because that's the established business relationship is 18 months. So if you sell a property to somebody now, for 18 months, and I hope you took from that presentation the varying degrees that the courts are interpreting this. Right now, the understanding is you can then continue to contact them for 18 months. The question would be, just because they consented one time, does that carry over for 6 months later or 12 months later? I think that's a gray area.
But it's probably always good standard practice to get that, if you put that in writing to get that authorization, the prior authorization, that's certainly a good first step.
So if we're sending out, 20,000, 30,000 postcards, and I have someone call us first, and we call them back, we don't pick up the phone, and we call them back, and they turn out to be out, and do not call us, or that's it.
I hope it came across in the presentation. If somebody has called you and left you their phone number, responding to a postcard, and they've left you their phone number, they've given express consent. Okay, so that's the first part. The second part, though, is if somebody has called, they don't leave that voicemail, and you go, ooh, somebody's called that one phone number we have associated with this postcard, we're going to call them back. They haven't given you the express consent because it was captured by the system as opposed to being given to you.
They originally called us on.
Understood. But again, the law as it currently is unless they leave you the phone number, just by capturing it on a caller ID system of some sort, that's not express consent.
Yeah, I think it's like a missed call. If you get it as a missed call, that wouldn't be prior authorization, prior consent. If we're on the do not call.
So let's be real clear on that. So if you still want to call that person, if it's that important to call somebody that didn't leave a voicemail but left a number, and think about the alternative, it could have been somebody that randomly, accidentally called that number. It wasn't somebody actually responding to a postcard, they misdialed. So if you still want to call that back, the first thing you do is check to see if it's on the do not call list. All that consent and written consent, that has to do with, am I going to text you? Am I going to do auto dial? Am I going to use some sort of pre-recorded message? If you manually dial, with marks as the concerning part, because if you're using your cell phone, your smartphone, right now it's so expansive, it may fall into that. But if you want to manually dial somebody because you have a phone number, check the do not call list first. For whatever reason, check the do not call list first, unless you've established that business relationship with them.
Always first off, check the list, and that'll at least give you the starting point. And again, because our cell phones, smartphones now, you can store people's phone numbers in there, and then part of that argument was that your smartphone may fall into that category of a device that holds and stores numbers. So
that therein lies the scary part, right? Because if you're involved in a lawsuit of any kind, the discovery and the deposition period, that's very, 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 very costly. Okay. And they're going to pull all of your phone records, any of your telecommunication records, and it's all recorded. It's on a server. Okay. So they're going to be able to see how many different violations there are just from one agent. And therein lies a huge problem for anybody doing this. In fact, Eric, would you comment on your conversation with Drucker, the Arizona Association of Realtors attorney?
So you saw
he's in-house counsel.
Yeah.
AAR,
Yeah, you said, and CEO, I believe, of AAR. So you saw my poor attempt at a graphic with the Florida cases popping up. As I was preparing this, I thought, well, this is really the impetus of this concern, is you've got this class action law firm going out and looking for cases, targeting real estate agents. Later on, as I was preparing and calling on another matter, I contacted AAR, I contacted Scott Drucker, and he advised me that there were now 4 current class action lawsuits in Arizona by the Florida law firm. They've hired an Arizona lawyer so that they can sit in their office in Florida and pick apart Arizona real estate agents and brokers. They're going to do it all over the country. So this is, and you saw why early in the presentation, because they're looking at $75 million settlements.
What it appears to be is the legal defense costs could certainly be many times more than the potential fine. If you lose the case, can you also get sued for the other side's attorney's fees?
I don't believe so, but also if you win the case, I don't believe you can necessarily get your attorney's fees reimbursed, because this is not a contractual matter.
So an average real estate lawsuit from AR is $80,000. So if you go through, that's why these people are settling, because the ticker is going up. He had an example that it could be in one call, $4,500, and you can spend $80,000 in defense, $4,500. That's why they settle.
So Jeff, wouldn't you say if they found one call and they subpoenaed your records and they find a whole series of calls, $4,500 then becomes 45 times maybe 1,000 calls. So that's what we have to consider,
Anybody.
doing our real estate practice.
It is scary, and really we're just here to educate you on what the law says, and so that you can do your business appropriately. You know, when I first started real estate, we didn't have cell phones, we didn't have fax machines. So what everybody did was send letters. Hey, your house is guarding TCPA and work against that. So,
One more comment. People ask, well, how do they find you? How do they find people for the class action lawsuits? Well, if we watch TV and we see attorneys on TV saying if you took this medication, okay, please contact our law firm. Could you imagine that attorney firm going on TV throughout the state, because there's enormous stakes for them and the legal fees that are the amounts that they're going to collect? Anybody who's had tiresome calls, please contact us. You can see the rest of the picture here. It's a nightmare situation.
And understand when we're talking about discovery and disclosure, because that's really the part me as an attorney defending somebody is really concerned about. We can't force somebody to settle. They can demand $4,500, they can demand $10,000, and we can come in and say, well, now we're ready to give you the $10,000. Well, that could be a cue to somebody. Ooh, they're scared. Before we settle with you, we want to go through discovery and disclosure.
And I think the consumer who joins a class action lawsuit has nothing to lose. If they qualify to be part of the class action lawsuit, it doesn't cost them anything.
why do attorneys do a class action lawsuit? They don't charge any money up front, but in the case, they get 30%. So this is $100 million. That law firm is $300 million.
Think of the tobacco company lawsuits and things that is
Huge deal.
But just like in anything else, you don't want to ever give anybody else ammunition to shoot you with. If you don't want to provide opportunity for them to come after you. Because if they get their foot in the door, like John said, with one violation, that's just the opening, because they're going to look at every phone call you've made in the last 6 to 12 months, and if they can find anything from that, multiple fines, then it just escalates really quickly.
So as you know, through those lawsuits we presently have, the one that other people in our company had, there are crazy people out there looking to do this. They're just trying to find a way, because it's a great source of easy income for them. So beware.
I said last week, unless you all have any other questions, and we'll close this out for today. We really appreciate you being here, and we want you to do business, but we have to follow the law. We have no choice. But the other comment is the Arizona Association of Realtors is currently reaching out to everybody, including the Department of Real Estate, to inform brokers throughout the state that these class action lawsuits. I've heard agents say, well, just go maybe someplace else where they don't pay as much attention to this. Well, that's foolishness. You want to be somewhere where the broker is paying attention. That's our job as a brokerage. That's Jeff's job, to protect the brokerage, and most importantly, protect you, our customer.
You're going to another real estate company, still doesn't change the law.
The laws and rules apply to everybody the same. But boy, a suit like this could put you out of business like in no time at all and make your life miserable. I don't know if anybody's ever been in a deposition, but they're not a very fun place to be. The attorney's job is to make you look like you're a crook, and they make it very uncomfortable. So you guys work too hard to lose everything too quickly. And again, it's like everything. As long as you follow the rules, you'll be fine.
All right, everybody. Well, thank you.
Thank you very much, guys. Appreciate it. Thank you, Eric.
Good job.
Well done.